Well, good morning, good afternoon, good evening, wherever you are. Welcome back to Wiley's Government Contracts podcast series. I'm your host, Craig Smith. Today, we've got an interesting topic, one that I think many of our listeners may go, oh, this doesn't apply to me, or I dealt with this. And that's with the proliferation of privacy laws in the various states around the country. You go, oh, privacy, and connections to my business, my website. I dealt with that with GDPR. I'm good, right? The answer is no. Oh, I'm a federal contractor. Am I good on that? Today, I think you want to tune in and get the answer to that from our experts here today, our partners, Kat Scott and Joan Stewart. Thank you so much for joining us. And so I think kind of kicking things off to get right into it, why federal contractors should care is a really important question. But first, just to give everyone a baseline, kind of where are we today, kind of high level with the state privacy landscape?
Awesome. Yeah. Thank you for having us, Greg. And I can take that first question. So to start, I think it's really important to note that in the U.S., there is no comprehensive federal privacy law. And that's despite numerous attempts from Congress over the past several years to adopt federal privacy legislation. So in the absence of an omnibus federal privacy law, states have really taken the lead on enacting laws that protect consumers' privacy. And state privacy legislation has just become an incredibly active space over the past several years. So many states have proposed privacy legislation. So far, 5 states have been able to get their bills across the finish line. So those states are California, Virginia, Colorado, Connecticut, and Utah. California's law, which is probably the one that makes the most headlines, is the California Consumer Privacy Act. And that's been in effect since 2020. This year, actually, though, they had an amendment that significantly expanded the scope of the law, and that went into effect January 1 of this year. Virginia's law also took effect on January 1, 2023. The next 2 that are online are Colorado and Connecticut. And both of those laws go into effect July 1 of this year. And then last up this year is Utah's new privacy law, and that comes into effect December 31st, 2023.
So it sounds like a busy year, but there could be more too?
Absolutely. So a busy year for compliance and coming into compliance with those laws that are taking effect this year. But 2023 is already shaping up to be a really active year on the legislative side too. So far, and we're only at the beginning of March, but at least 20 different states are actively considering omnibus privacy laws. It stands to be determined with which ones are going to pass, but we expect at least some of those states to get new privacy laws on the books this year.
So it's a different conversation if we're having this in 2024, for example.
Absolutely. And that's sort of the bottom line here. There's a patchwork approach to privacy legislation at this point across the U.S., and states are leading the way in driving privacy compliance obligations. And that patchwork approach, that state-by-state approach, makes things really complicated. It makes it complicated to monitor. It makes it complicated to comply with. And so while the laws adopted to date share a lot of key elements, there's just overlap and differences that need to be carefully tracked. And with more laws likely to be adopted, this is just a space that companies need to watch really closely.
It's going to start turning into a bingo board. And so now that we have that, and thanks, Kat, that's great to know. Kind of, Joan, as we think about, and I mentioned this a moment ago, like, I don't sell widgets to consumers. I don't run a social media empire. I'm really just a federally focused, or even maybe a state focused contractor in a state that doesn't already have a law. Why do I care about this? And I think that's a question that's really important for folks to pay attention to, right?
Yeah, absolutely. And thanks for having us on this podcast as well. But you make a really good point that I think a lot of businesses out there just either see exemptions to the law or don't think that it applies to them. But the short answer here is that federal contractors need to at least pay attention to these laws and take a look at these laws. Because they may impose direct compliance obligations on the business, or at least certain portions of your business, because the scope of these laws is really incredibly broad. Let's start with just getting a handle on how broadly they define personal information, which is really at the base of all of these laws. So the definition of personal information boils down to any information that is linked or reasonably linked to an identified or identifiable person. So this casts such a wide net and much wider than many companies have traditionally thought of as PII. I think kind of the old definition of personal information was basically name, address, social security number, or somebody's credit card. That is really outdated, and we have moved on to this much broader definition. So this new definition definitely captures that kind of traditional information, but it also adds in information like IP addresses or device identifiers, information that's captured if your website is doing any kind of tracking of analytics or using any kind of digital technologies. So it can also include information like audio or video. So think about all the Zoom calls that you may have recorded over the past 3 years. That is personal information. And if your business has a public-facing website that is using analytics or allows individuals to sign up for a newsletter or even contact you for more information, then you are also collecting information.
So all those things that may be aimed at really focused on contracting officers or subcontracts administrators just to get the word out about your contractor, that's the sort of stuff. The analytics may be informative, but it sounds like they may need to be managed with care.
Absolutely. And it really can trigger some of these affirmative obligations under the laws that we'll talk about a little bit more in a minute, but things like having a privacy policy. So I think it's really important not to overlook the different ways, casting that wide net of personal information, but thinking about the different ways that you may be collecting it.
But Kat said it's a patchwork, and we know that not all the laws are a little bit different. So not everyone's going to be covered, though. So when we were trying to say pay attention, it's not every single contractor. There might be some who are not covered.
Right. So there are various exceptions or exemptions from these laws that, again, we, especially federal contractors, should closely analyze to determine whether you fall within these exemptions. So generally speaking, the state omnibus privacy laws apply to a legal entity that conducts business in that particular state. These laws do not restrict or regulate the federal government. And so even though the federal government is not subject to the law, that doesn't mean that all operations from a government contractor get exempted out as well. So for example, if you have employees in California or contract with non-government entities, those activities could be covered under the California privacy framework because that privacy framework is broader than any of the other state laws and applies both to employment and B2B data. And likewise, all of these state laws have a variation on exceptions for entities or data that's regulated under specific federal privacy laws. And I think this is what you were getting at a minute ago, Craig, such as HIPAA or Graham-Leach-Bliley Act. However, it's important to note that these carve-outs are not uniform across the state laws. So some of the states would exempt data, and others may also exempt the business that processes that data. So practically speaking, this may mean that if your HIPAA-covered data processing activity could be carved out from the law, but your other types of data processing could still be regulated. Really, bottom line here is that these laws are complex, technical, and nuanced, and it's really important to look at all of your business operations, everything from HR processing to the work you do pursuant to those government contracts to work you do independent from a government contract to determine if and how these laws may apply to your organization.
So there's a lot there, and I think it's really important people appreciate that there are going to be some differences probably at the edges. But let's say I'm a contractor, I've gone through the exercise, and I said, okay, and I pick up the phone and I say, Kat, I'm covered by at least one of these. I'm pretty confident you can confirm it for me. What do I have to do?
Yeah, that's a really good question. So, we've covered this, but I think it's worth covering again. All of these laws are different. So the requirements from Virginia to California to Utah, they'll be different. But the good news is that they all do have some continuity and consistency between them, and they generally follow similar models. So at the highest level, each of these laws do two things. They impose affirmative obligations on businesses or controllers. And controller is a term that many of these statutes use to say the business that collects the data. And then the second thing that these laws do is that they establish consumer rights with respect to covered personal information or personal data. So we can take both of those buckets and break them down into sort of the general requirements that would be expected of you if you are covered by these laws. So first, with respect to the affirmative obligations, these laws require covered businesses to comply with a variety of privacy requirements. This includes transparency requirements. That's providing public privacy notices and other notices to end users and consumers. It includes security requirements. So the requirement to establish reasonable security practices that are appropriate to the data being collected and used. There are also pretty complex data governance requirements, and this is where stuff gets tricky. These are requirements like data minimization requirements, purpose specification and secondary use limitations, and also retention and deletion requirements.
So, and if I could jump in, I mean, what I hear is also putting my government contracts hat on, a possibility that these state law requirements might be different from or even potentially conflict with contract requirements I'm getting from the federal government, right? So it's important to study them closely and figure out how they join together.
Yeah, absolutely. I mean, whenever you're talking about this level of prescriptive requirement, you have to do X, Y, and Z. And you're an organization that already has a long list of prescriptive requirements that that you have to comply with. That's exactly right. You have some risk of overlap, risk of conflict, and it gets really complicated. The list goes on with the requirements on controllers. So the most of the state laws require controllers to conduct data protection assessments for at least some kinds of processing, typically higher risk processing like selling data, collecting sensitive information. And then there are contracting requirements. And this is something this audience is probably very familiar with.
So you have my attention.
This is where a business or controller has to enter into a contract with a service provider or processor that is actually processing this personal information. And these requirements definitely vary from state to state. But for the most part, they impose pretty detailed and prescriptive requirements for what is required to actually be in the contract.
Yeah, and if I could just jump in there, I think it's important to note that these contracting requirements are noteworthy because many businesses find themselves on both sides of the equation. In some instances, you're the business or you're the entity controlling the data and you're entering into a contract with somebody acting as a service provider or a vendor to you, and you need to negotiate and impose these restrictions on them. But you could also be on the flip side of it where you are actually being hired to perform a service and you're going to be asked to enter into these contractual requirements and place these affirmative obligations on yourself to process the data in compliance with them. So I think it's just important to note you aren't always going to be playing the same role when it comes to these contracting requirements. So you need to be aware of what's involved in both sides of it.
It reminds me of, when it comes to flowing down terms in a contract, how do I feel about it? Well, am I advising the prime or am I advising the sub?
Exactly.
That's exactly right. And it's a really important point, right? Your organization can face obligations under these laws in a variety of different roles. And so it's important to pay attention to your exact business operation in that moment to figure out where you are in the equation. Okay, that brings me to the next bucket of requirements, and that is consumer rights. So if you're covered under any of these state laws, you are going to have to establish mechanisms to offer these specific consumer rights and then also to honor these consumer rights. And they include the right to access or know the personal information the business has collected about a consumer, the right to correct information if it's incorrect, the right to delete information in certain circumstances, and the right to port certain data. The last right that is consistent across most of these state laws is the right to opt out of certain processing. And again, this one varies in terms of what you can opt out from, but the opt-out options range from sales of personal information to opting out of targeted advertising and also opting out of certain automated processing or automated decision-making.
Yeah, Kat, this I think is the consumer right that has gotten the most press out of all of these omnibus state laws. There's a lot of talk and about this right to opt out of the sale of your personal information. And many of these laws were actually triggered by that frustration around online marketing and specifically ads that were being targeted based on your online activity. And so all of the state laws have incorporated this concept that you need to opt out of the sale of personal information. But the issue is they have all defined sale differently and really much broader than what we think of as the dictionary definition of sale. So ultimately, what it boils down to is that any transfer of personal data could be considered a sale. And if you don't intend that that transfer of information is a sale, such as sharing information with a service provider or a vendor, that's where you need to have those specific contractual provisions in place that restrict what the service provider or vendor can do with the information you sent them. But that broad definition also means that you have to take a close look at the information your websites may be collecting in the background. This is information collected usually through the use of cookies or other online technologies, because if you're sharing that information with a third party, such as an analytics provider or an online marketing partner, that could also be considered the sale of information as it is being defined by these state laws. So that really imposes, again, those additional obligations on you where you think, I'm not selling data. I would never do that. But if you're using online analytics, you may be.
It's like you're almost doing the opposite. I'm paying someone to analyze this for me. I'm not selling it. And yet under some of these, it sounds like that could be a trigger or a consumer right here.
It absolutely could be. And it again, I think it's a much broader way to look at this than the typical business sense would be to consider this not to be a sale, but regulators have taken a very, very broad view of it. So,
and our audience will be familiar with the metaphysical debates about when is a contract for purposes of government contracting. It sounds like when am I actually selling something? Could be when I'm not actually selling it.
Exactly.
But we know, we've heard today, 2023 is going to be a busy year with requirements already on the books and new ones. And there's an effort that everyone needs to be thinking about to figure out, am I covered? What are the obligations? But okay, great. What do I do? What are some practical next steps I can thinking about with my organization to figure out, Joan, kind of what to make some sense of this and try to get some order to compliance?
Yeah, so absolutely. There are definitely kind of some logical next steps that you can take to wrap your head around this. So first, determine, are your business and data collection practices within the scope of one or more of these state laws? The laws don't require that your business has a physical presence in the state, but rather they're triggered or may be triggered when you collect information from a certain number of individuals resident in that particular state. And also remember that California has that expanded scope. It includes B2B data and employee data in the type of consumer data. So you have to factor that into your analysis. And that really has honestly pulled in a lot of businesses that otherwise would have probably been exempted from California's law. So next, make sure that you actually know what data you collect. We go through a lot of data mapping exercises, and sometimes it's a little bit of a shock to like the business unit, what the sales unit is collecting and otherwise. But know what data you collect, know how you use it, know how you share it, know the life cycle of your data. And usually we track this with a data map. But I think that's, know the path that your data follows in your organization. I would use this opportunity to really revisit and refresh your data retention and data minimization policies. So all of these laws require that a business really be thoughtful about collecting and retaining data. The days of holding on to data just in case it may be useful in the future are long gone. And finally, we've talked a lot about those contractual terms. Those are an important compliance obligation under each of these laws. So when you're sharing or transferring personal information to a third-party service provider or vendor, the use and processing of that information really needs to be addressed in a written agreement. Each law has very specific disclosures that must be addressed in the written agreement, and of course, they are all slightly different, which isn't helpful. But if you do not intend that the sharing of that data if you don't intend to sell data, then you really need to make sure that your contracts have those correct terms in place.
Seems like a lot of subtlety there, potentially.
Yes. It can be, like I said, there's differences between those, but we've been able to generally consolidate these into kind of centralized terms. I think anybody engaging in this space has gotten used to seeing a data processing addendum attached to almost every contract that is now out there. And so I think this was a shock to the system when California's law took place in 2020, but it's becoming more commonplace these days.
And so what other resources do we have maybe to help folks aside from I've picked up the phone to call Kat today already, but what else is out there?
Yeah, absolutely. So we've shared a lot of information with you today. We hope you found it helpful. We put together a guide that is available on our website that provides a high-level overview of each of these state privacy laws that is currently in effect that I think you may find helpful in conducting that kind of initial assessment of whether your business is within the scope of these laws. So to obtain a copy of the guide, please go to our website at wiley.law and type state privacy laws into the search bar, and it should be the first thing that comes up for you. And of course, our Kat and myself and our whole privacy and data governance team is ready to assist if you have any questions or if you need any advice on privacy compliance.
Well, Joan, Kat, I think the first thing I'm going to do is take the California flag and wave it outside all my clients' offices to get their attention, because I think that is just not intuitive, won't be intuitive for a lot of people. And I've heard you say anecdotally that you've had some clients who that was a real surprise for them. So I'm really glad you both were able to join us. Thank you both so much. And to our listeners, we'll talk to you next time.
Thanks so much for having us.
Thank you.